Brandon blog is titled Canadian Debtors Association Urges Essential Changes to Bankruptcy and Insolvency Act. My name is Ira Smith, President of Ira Smith Trustee and Receiver, Inc. First, we hope that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver, Inc. remains fully operational. Both Brandon Smith and myself are handling all meetings by telephone or video. So if you have any questions at all, shoot us a message, give us a phone call. We would love to hear from you. I hope you can watch until the end of this video, because I know you will get value from it. Brandon discusses a recent press release by the Canadian Debtors Association. This association is a national nonprofit group which was established a few years ago, and its stated aim is to advocate on behalf of debtors in financial trouble. And this is a good thing. Brandon talks about why the association was set up and why and how they believe they can build a better debtor experience. The association agrees with the aims of the Bankruptcy and Insolvency Act, which is everyone deserves a fresh start. And that's the purpose of insolvency legislation in Canada and the Canadian insolvency system. Brandon then goes on to explain the problem that Canadian Debtors Association has identified. And it is a real problem that Brandon has written about before. And the problem is that the Canadian credit bureaus, Equifax and TransUnion, when they have the credit reports for people who have filed either a consumer proposal or a Division I proposal and have successfully completed them, they do not differentiate in the credit scoring between that and someone who filed for bankruptcy to any significant degree. So it means that someone who has used a valid legal insolvency system process to avoid bankruptcy does not get sufficient benefit in their credit reporting than someone who'd filed for bankruptcy. Now, the Canadian Debtors Association goes on with their view of what the solution is to the problem, which is to amend the Bankruptcy and Insolvency Act so that credit reporting does make this differentiation. Brandon discusses his view on the issue, explains that the legislation that affects credit bureaus is provincial or territorial, not federal. He discusses the difficulty of getting a member's bill passed in Parliament to amend the Bankruptcy and Insolvency Act. In his view, and I agree, that's not the right solution. There's a much simpler one, which is advocate on behalf of debtors directly to the credit reporting agencies. Why not even team up with another association, such as the one that represents all licensed insolvency trustees across Canada, the Canadian Association of Insolvency and Restructuring Professionals? Go directly to TransUnion and Equifax. There's only 2 credit reporting agencies in Canada. Sit down with them see if a different framework can be developed. If that falls on deaf ears, then lobby the different provincial governments to put it in their legislation that the credit bureaus already must adhere to, and make those changes that way. So that is what this Brandon blog is all about. I hope you can read the entire blog below, because I know you will find it informative. Again, the Ira Smith team hopes that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Both Brandon Smith and myself are available anytime to answer any questions you may have. We are holding all meetings by telephone or video. So if you have any questions about this Brandon blog or anything else at all, shoot us a message, give us a phone call. We would love to speak with you.